Hi, everyone. This is Gail Pendleton. I'm Executive Director of ASISTA Immigration Assistance. And if you're unfamiliar with us, we'll come back at the end and talk to you about how we can help you with your work with immigrant survivors. I am working today only with Maria Lazzarino from our staff, who's going to help with triaging your questions. Cecilia is on an airplane today. So I think what I'd like to do, just a couple caveats before we begin, is hold your case-based questions until the end. Maria will organize them for me so you can put them in earlier. But if you have questions, asking questions about what I'm actually saying, like what does she mean by an RFE, that kind of clarifying question, please put that in as soon as I say something that you don't understand, and Maria will ask me to explain it more. It's hard for me to follow the chat and present in a way that's not really boring, so she's going to help me out with that. Another caveat is that, we are basically funded by the Office on Violence Against Women to give you more intermediate and advanced training. So that's what this is about. It assumes quite a bit of knowledge and practice in VAWA and U visa areas. But given it's a fairly small audience, and I think we're going to be able to get through the slides before the end of the webinar, I'm happy to talk to you about some more basic questions that you have as well, because this is a very complicated area, and it's important that you feel secure in what you're doing as you're working with immigrant survivors. Finally, you'll see a lot of resources attached here. Many of these come from some of our prior webinars that got kind of more in the weeds on very advanced topics, but hopefully they will all be helpful to you. And if we mention anything today that isn't in those materials, we will be sure, Maria will take note of that, and we'll be sure to send it out to you afterwards. Okay, so the goal of today's webinar, really just one goal, is to help you apply best practices in your responses to requests for more evidence from Citizenship and Immigration Services, denials from them, and some practice tips that we have gleaned from our 20-plus years of working with them to prevent those kinds of responses. And what you'll see is I'm going to start by reviewing with you some of kind of the background standards, burdens, general practice that we see, and then, sorry, my cat is getting up on me, down, honey, and then get into typical common issues that we're seeing with VAWAs and U visas with the government, and we can talk to you a little bit more about some of the arguments that we've been developing to address some of those. Okay, so this is review. For those of you who aren't lawyers, this is kind of standard in the legal system, is that you have a burden of proof, which is how much evidence do you need to show to win your case. The one you're probably most familiar with is beyond a reasonable doubt for criminal cases. In this area of the law, it's a fairly liberal burden, largely because it's for victims of crime. So it's called the preponderance of the evidence, and you just need to show, theoretically, that it's 51%, more than half likely that what you're arguing with the evidence that you submitted proves your case. Now that's the burden. The any credible evidence standard, okay, so here are the forms of evidence that in the immigration system they're used to receiving to meet that burden of evidence. It's the kinds of evidence. Primary evidence is the kind of thing that you would see from systems. So it would be a police report or a hospital record of a domestic violence. And as those of you familiar with domestic violence know, often survivors aren't going to have that kind of primary evidence. The system itself, the immigration system itself, in some cases allow people to provide secondary evidence, which is things that aren't necessarily from the system, but for instance, they're declarations by people who would know more details. They may be other sources of information that seem credible. But even that may be hard for many survivors to obtain. So for the VAWA self-petitioning and the U visa and the T visa, Congress created a special evidentiary standard, which is called the Any Credible Evidence Standard. And I think there are some misconceptions sometimes about how that applies. It doesn't mean that you can just throw anything at them and say, okay, this all is credible, therefore you should take it. In general, what you want to do is show that the evidence that you're supplying is the best evidence you can find. For instance, why you don't have good police reports, why the police reports you have aren't very good, or why, even though she's a victim of domestic violence, she may not have a good hospital report, because that's the kind of evidence they would, without being well educated in domestic violence, might expect to get. That would be what they consider primary evidence. So you want to explain why you can't get the primary evidence and why you are instead showing this credible evidence instead. Okay. And there is this really helpful memo that is in your attachments. It says it's about extreme hardship, which is no longer a requirement for VAWA, but it later on discusses why the anti-credible evidence standard makes sense for survivors. Basically what you all know, which is that abusers control the normal documents, and they may not allow survivors to be on, the rent agreement or the tax documents or the bank statements, which is the kind of thing that the government would normally want to see. So sometimes if you encounter a new adjudicator who hasn't been well trained on domestic violence, we may work with you in response to a request for evidence, citing this memo and having you or your domestic violence partners explain why your client can't get this kind of evidence because she's a survivor and why the evidence that she is supplying is credible. Okay, so that's a little preface to how you prevent getting requests for evidence. This isn't surefire, I have to say. So these are just some ideas that we've learned through experience that we'll come back to you. If you say, oh, I got an RFE, we'll come back and say, okay, let's review how you actually filed the application. And because sometimes it's just they're confused. So one thing that's really important to do ahead of time, I call it the heading it off at the pass strategy, is go through everything that you're filing and everything that you know has been filed for your client in the past, if you can get it. So if your client is married to an abusive U.S. citizen, he may have filed an application for her, an I-130, to get her status as a spouse of a U.S. citizen, and then, he was controlling the situation, so she broke away and filed her own 360. You're going to want to look at what's in that file that he submitted as well as what's in her file, because inconsistencies are the death to this kind of application. If they start worrying about whether your client is telling the truth, whether she or he is credible, then it's very hard to convince them that she's shown her case, regardless of how much other evidence you provide, because they think she may be lying. So they will seize often on silly little inconsistencies that we don't think matter, like dates that are different, addresses that are different on the forms. You want to, before you file anything, you want to go through and highlight all those and have her explain in a declaration why there are differences, because often there's a legitimate difference. For instance, the dates may be because someone forced her to choose a date, but in the culture she comes from, she thinks about dates by it was a month after my son's birthday kind of thing. And so she was forced to choose a date, but that wasn't how she would have done it if she could really control herself, what information she provided. More often you'll see discrepancies between what the abuser put into documents in a prior filing and what she is now saying, for instance, on tax records. You want to address all of those discrepancies up front when you file in her declaration so that they can't come back and say, well, we see this difference. Why didn't you tell us about that? And it makes us wonder what about the rest of it. What we've seen is that once they see a major discrepancy like that, they will go through the whole file with a fine-tooth comb looking for inconsistencies. Now, material, for those of you who aren't lawyers, material is a very important legal concept. It means, does this actually go to whether the person is eligible? So there may be discrepancies that we would argue have nothing to do with whether the person is eligible as a victim of domestic violence. And that's the kind of thing that we can work out with you as we do technical assistance with you. Also, really important to do the first time you file, especially if you aren't doing thousands of cases and have time to do this, is to do what we call a roadmap cover letter, which is in your cover letter, instead of going through exhaustive detail about why your client is eligible, literally bullet point how she's eligible and say she suffered, for instance, she's a VAWA self-petitioner. She suffered domestic violence in the form of humiliation and degradation and economic control. See declaration by her at paragraph 4 through 5 and see declaration by counselor at paragraph 7 through 10. That's just an example. But if you do that, it's really easy for the adjudicator to pull out his or her checklist, look at the actual documents you're saying, and check off the checklist. And I like to have you picture in your mind you are an adjudicator up at the Vermont Service Center in a teeny little cell that's like 6 by 6 with piles and piles of these applications in front of you. You open up an application that's just a whole bunch of documents as you're drinking your coffee, and then you open up the second one. It has this beautiful roadmap cover letter. Which one are you going to do first when you open up the files? So think you're in their shoes. How can you make it easy for them to decide that your client is eligible? Similarly, it's very helpful if you do an index to documents. And if you're not familiar with that, I think, Maria, we do have samples of that on our website, at least for U visas, and we can send you some of those, both the roadmap and the index after this. Because that, again, you organize that by eligibility requirements. So, for instance, for battery extreme cruelty, you could say, you know, evidence of humiliation, degradation, and economic control are, you know, the declarations we talked about, declarations by other people who might know about it. And again, what I suggest you do is you note in your short description of each document where you want the person to look to find that evidence. So that if I'm under the gun with 100 cases to get through today, all I have to do is look at your index, say, okay, I need to go to paragraph 3 on page 4, and then when I look at your paragraph 3 on page 4, it's literally highlighted so that I can see that that's all I need to read to see that, yes, you have shown that. Okay. Sorry, cat's attacking me. Ah! Sorry, I've been away for 2 weeks, so the cat just wants to sit on my head all the time. Okay, these are some tips from the Vermont Service Center. What is helpful? You have to have a G28, which is basically the notice of appearance as an attorney or a BIA accredited representative. And if any of you don't know what a BIA accredited representative is, put a note in the chat box and I'll come back to that, because we work with the Catholic Legal Immigration Network to help train you guys on that. And it's a really useful way to expand your resources. But you have to have one of those for both the principal applicant and, for at least for the U visas, the derivative applicants, because they're going to end up being their own U visa holders. And the Vermont Service Center, or the Nebraska Service Center, which is now doing some of these cases, will only communicate with people who have G28s. So if you're sending emails to that special email hotline and you're not getting any replies, I would double check that you're attaching your G28s when you do that. And again, that's one of the things we're here to help you with, is how to contact the government when you have problems. It's helpful to number the pages sequentially from the beginning and not have a lot of internal numbering, or have both. And it's one thing you need. Some people like to organize their files like with little tabs sticking out. The problem with that is that as soon as they get your file, they basically take it apart and put it in a new kind of file holder and cut up all the tabs. So what we have found is it's probably more useful to separate out sections with just colored pieces of paper. And again, having that index will help them follow through without having a lot of tabs attached. Double-sided is hard for them because they may not see the second side because of the way they take apart your files and organize them. Let's see. The derivative documents.
We have Claudia is telling us that now the BIA representatives are being called DOG, Department of Justice representative.
Oh, okay. That's interesting. Thank you for that update. Okay, but I assume it's the same thing, and I'll come back and explain that later on. Thanks, Maria. Okay, and so there's some issues we can get back. I don't want to get too much weedy about how to to submit files. But there's often problems when you have U visas and a lot of derivatives with their files getting separated. So if you have those issues, we can come back to that at the end. Or again, it's the kind of thing that can help you figure out through individual technical assistance what's the best way to organize it. So here's their suggested order of documents. Again, your notice of appearance, the forms you have to fill out, like the I-360 for the VAWA self-petition and the I-918 for the U visa, and then these other supporting documents. So the I-192 is that waiver application for the U visa. And as you can see, there's a bunch more forms for the U visas in the order that they should be in. It's not fatal if you don't have them in that order. But again, remember, you're trying to make it really easy for the adjudicator to figure out, first, you filed everything you need to file, and second, you've proved everything you need to prove. Okay, so here are some of the common requests for evidence that we see, and these are general for responses. You always need to respond on time. Even if you don't have what they want, you got to respond timely by the deadline. And I would strongly encourage you to, for yourself, set a deadline that's 2 days before the actual deadline. And one of the reasons for that is that the way the Vermont Service Center works is that the VAWA unit doesn't actually get any files that the building receives on Friday until Monday. And we've seen a lot of pushback on individual cases where they say you didn't file this timely, and then we have to tell them, no, the law says that as long as we show you got it on Friday, it was filed timely. Just avoid that. Try to make sure you get this filed a couple days before the deadline. And if you don't have what they're asking for, again, contact us as soon as you get a request for evidence, and we can go through with you on how to respond and what you need to put together and what to tell them if you can't get what they're asking you for. Always, always, when you're communicating with the government, put the last document that you received from them on the top of the pile. And this is to avoid problems with their mailroom, which is craziness if you've ever seen it. It's literally people whose only job is to rip open these envelopes, immediately decide which part of this very large building this document is supposed to go to, and throw it into the appropriate pile. And there's a special VAWA U visa unit, and you do not want your case going off to one of the other units because it's virtually impossible to get it back if it disappears. So by putting the last communication from them on the top, that makes it easy for the mailroom to see where it should go. Another practice pointer that's not on here is that always put on the outside of your envelope and on the first page of what you're filing in big red letters, VAWA unit. And that way the mailroom knows that this is a special file that's going in that special pile, that special box, and it shouldn't go off into some black hole at the Vermont Service Center. You should always respond in full to the RFE, and again, that goes back to how do you answer things that they're asking for, either that they shouldn't be asking for, that you already provided, or that you can't get. That's what we help you figure out. But the reason you need to respond timely, you can ask for more time, but you've got to respond timely, because the easiest way for them to deny a case is to say you didn't follow the proper procedure without getting into the merits of your client's application at all. And you want to avoid that, because what we have found, ironically, is that's a lot harder to fix than when they're wrong on whether your client actually qualifies. It's much harder to fix it if you missed a deadline. And be civil in your response. I know it's often very frustrating that they don't seem to have seen what you submitted, that they don't seem to understand domestic violence. We can help you, frame your criticism in a way that is most helpful to them, and we actually use those examples to work with the government on where their staff needs to be more trained. So again, that's why it's very helpful if you contact us sooner rather than later when you get these kinds of responses from them. This is what I was talking about. The best evidence is the most credible evidence. So that's the way to think about it. Any credible evidence means the best evidence you can get, basically. Again, they think it's systems evidence, so show how you tried to get it and why it didn't exist. Why didn't she call the police? Why didn't she go to the hospital? If she did, why was that not useful? She didn't reveal. Very typical, right? But you still got to explain it. Don't assume they know that. And then, given that you tried this hard to get all this evidence that they want, here's what you were able to get. to prove that she was a victim of domestic violence, or that she has good moral character, or that she married in good faith, or whatever the issue that's a little problematic that you have in your case. Okay, there we go. So this is now getting into some of the common kinds of RFEs that we've seen in the past. It always happens when they bring in new adjudicators. You'll see them, I feel like they're looking at what you're supplying and just throwing their hands up in the air and saying, I can't figure out what they're trying to show, so I'm just going to send back this boilerplate RFE that lists everything that they have to show. The supervisors at the unit have many times said they're not supposed to be sending you those. They're supposed to go through the evidence that you supplied, explain why the evidence you supplied is sufficient, and then tell you what else you're supposed to supply to meet the requirements. So if you are getting requests for evidence that just list all the things that you have to show and the kinds of documents they want without talking about the evidence you supplied, that's a boilerplate RFE, and you should let us know right away, because the supervisors want to know if the adjudicators are sending those out. It indicates they are not well trained. And it may go back again to that how you organize your documents. So we may in turn suggest that you do that roadmap cover letter and index them to help them follow what your arguments are. Again, this is very typical. They often will ask for documents that you already submitted. My view is that you should not kill yourself trying to get documents that they're asking for if you've already submitted sufficient documents, but you may want to check in with us on that. I think you should be able to just send back what you, like the index and the roadmap, and literally put in red, hello, here's what we supplied, this is what you're asking for, you already have it. Because it's a burden on you and your client to be doing extra work that you shouldn't have to be doing if they were actually reading what you had sent them. And often we are seeing that the requests for evidence are just wrong. They may be wrong on the facts, they may be wrong on the law. They may be asking for documentation that isn't material, that isn't directly relevant to whether your client is eligible. They may mischaracterize the evidence you supplied. Often, I think this comes out of not understanding domestic violence and the context of survivors, domestic violence or sexual assault, and being a victim of a crime generally, and the context of survivors, and why the evidence you're supplying does meet it. And sometimes they're inaccurate description of the facts that you have supplied. So again, always respond timely. We have in the past always suggested you ask for supervisory review through the email hotline. It's probably still worth doing it, but I have to say these days we're not seeing the hotline fix hardly anything except purely procedural problems, like they're just wrong on the date, that you filed it or something like that. So what you do is you CC me or Cecilia when you do that, and when you don't get a helpful response, we then talk to you about, okay, what's your next step? Do you want to do a motion to reopen? Do you want to take an appeal? What else can we do? Okay, so let's get into some of the common requests for evidence we're seeing with VAWA self-petitions. I think a lot of it comes down to declarations, and so it's important to review how to do credible declarations. And having gone back and forth with Citizenship and Immigration Services many times over the years about what makes a declaration credible, the way I see it now is you got to just do lots of boring factual detail. I think and this is hard for survivors often to provide because it's re-traumatizing, which is one reason we strongly encourage a holistic team approach with your domestic violence counselors. Because if your domestic violence counselors or sexual assault counselors are already getting the story, there's no need for the immigration lawyer or DOJ, accredited rep, to do it again. Work together to get the story and to frame it in the way that's helpful for the government. So for instance, we often see in the VAWA area lots of problems with them believing it's a good faith marriage. And a lot of it, I think, is because petitioners will talk about, I was really in love with him, he was really romantic, but not give boring factual details. So what I say is, instead of saying that, literally go through, strike out any adjectives or opinions and adverbs, and make the applicant describe it. So when was the first time you connected with him or her? what did they say? What did you do? Now that you've been living together for a while, what's your routine? So, for instance, I think it's more persuasive to say, you know, we go shopping every Friday night, and he's in charge of buying the eggs and the bread and the fruit, and I'm in charge of buying the meat. That kind of really boring detail, idiosyncratic, like specific to your person detail, is what makes it credible to them. Because remember, they are never going to actually meet your client. They're never going to interview them, which is very different than a lot of other applications in our immigration system. So the only thing they have to tell whether your client is telling the truth and to really understand their story is what your client is saying in his or her declaration and what others are saying in their supporting declaration. So the same thing applies to counselor declarations, to declarations from family members or friends or other neighbors who are providing declarations. It's the nitty-gritty factual detail that's going to make it real for the people reading the application. Sometimes we're getting requests for evidence on abuse. And again, I think this has more to do with new adjudicators coming in who don't really understand domestic violence or who are applying their own version of what domestic violence is to the facts that they're reading. If you are seeing any RFEs that dismiss these supporting letters from those who did not witness the abuse firsthand, that's that primary evidence standard. It violates the anti-credible evidence standard, and the headquarters has agreed with us for years on that. So that we can fix immediately, and you don't even need to respond to that directly. We'll help you with that. They may say that, you know, this person basically went to see a counselor just to get that. That doesn't mean that what the counselor is saying isn't true. But this goes to why the details of what the counselor says in the corroborating declaration are very helpful. The very first time that I went up to do a training for the Vermont Service Center in the late 1990s, they said, please tell your lawyers and other people who are applying that we do not need something from a psychiatrist saying that she's suffering depression and PTSD. That really doesn't tell us anything about the domestic violence and how it's affecting her. What we actually love to see declarations from domestic violence counselors who can talk about how she told me this and I believe her because, you know, I've interviewed thousands of survivors and I can tell when they're telling the truth or not. And even though this is a very weird detail she's telling me, like, you know, he used to pull a phone out of the wall, or he would make me count back the pennies when I came back. That's very typical of abusers, and I know this because I do lots of work with domestic violence survivors. That's much more persuasive with the government adjudicators than something that talks about, you know, she's depressed because she's a victim of domestic violence. Just talking about them attending counseling sessions is not enough. That you could do, I mean, you know, people who get DUIs are forced to go to AA. It doesn't necessarily do them any good. So the fact that you're going doesn't necessarily prove that you're a survivor. What proves it, again, is that factual detail, and that factual detail from counselors explaining why it's domestic violence is what they need to see. One of the things that you should have in your materials is this 4 VAWA cases, DV advocate guidelines. It's not a template for you to fill in, but it helps you and the counselors you work with figure out how to organize a declaration. In case they've never done it before, it really isn't as hard as it may sound. First paragraph you do this, second paragraph you do that. That's what the guidelines tell you. Okay, we discussed a little bit about corroborating declarations. I think these are most helpful when you don't have systems evidence of the domestic violence and it's a form of domestic violence that may be unfamiliar to people who aren't well versed in all the myriad horrible, insane ways that abusers can use power and control. Most often that would be things like humiliation, degradation, economic control, the things that I've been emphasizing because I think until I got trained on domestic violence, I didn't realize that those could be forms of domestic violence. And there may be very idiosyncratic forms that are just specific to your client, but that matter to her because of the subjective experience that they cause in her. So this is what the guidelines tell you. basically. This is the first paragraph. You explain how you know it. You provide detailed facts. The opinions, like it's not helpful for them to say, I think she's a victim of domestic violence. It's helpful for her to say, she suffered the following forms of abuse, and here are the examples. He pulled the cord out of the wall on Monday the 15th, then the Friday the whatever, and every time he sent her out to go shopping, he gave her a list and a certain amount of money, and when she came back, he would count the change. That level of detail is what you need. But this is where the impact on the survivor can come in, because your survivors may not be able to articulate the impact on them, or don't feel comfortable doing it because it's re-traumatizing. If that's true, your DV counselors or other corroborating declarations can talk about that. And again, it's not the PTSD. It's like it would make her feel completely frustrated and that she had no control over her life, that she couldn't buy, pacifiers for her child because he was controlling it. That level of specifics, and that this is very typical of abusers. You see it all the time. Okay, so again, I think we've already kind of covered this. If you are a counselor or are working with counselors, I suggest sharing it with them. I think it helps overcome the kind of psychological barrier to do something quote-unquote legal. It's really not that hard. This is the place, good faith marriage, is the place we're seeing the most problems with VAWA self-petitions. And we're actually having to help people do appeals to the Administrative Appeals Office on this. So I can't say this is a surefire way to overcome those problems, but if you do what we've been talking about in terms of detail, and especially talking about how they met the abuser and the intent going into the marriage, any history going up to that, is crucial for the government, because they look at case law that says that it's the intent at the time you enter the marriage that counts. And I think they've kind of flipped that to mean that's the only time it counts, but it's definitely important to talk about the courtship and the decision to get married and all the facts going up to that. And then it's fine to continue after that in the context especially of domestic violence, because often that'll actually heat up after they get married, of why did she continue to stay? How were they actually living together in a spousal relationship? And if love wasn't the reason for the marriage, that doesn't mean it's not a good faith marriage. Love has only become the main reason for marriage in our society in the past 150 years. Prior to that, people got married because families were, economic reasons. We're connecting for economic reasons, or security. Often for women, it's security. That's a perfectly legitimate reason to get married, as long as it wasn't for the purpose of getting immigration status. It's okay if the person she's marrying wanted to accelerate his or her ability to get immigration status, but it can't be the only reason that she's marrying the U.S. citizen or lawful permanent resident. And I think we've covered this. Why don't you have the evidence that they may want, and why the evidence that you're supplying is credible? And we have several amicus briefs, which are friend of the court briefs that we filed to the Administrative Appeals Office, that identify all of the legal problems we're seeing and how they're addressing this. So if you think this might be an issue, you might actually want to read them ahead of time so you get a sense of what the issues are. And then please feel free to cut and paste any of those legal arguments and apply them to the facts in your case. Okay, the big issues that we're seeing with U-Visa RFEs, and again, I'm happy to come back and discuss more of this once I'm done. Let me just get through all this, and then we can come back into questions. These are the big questions we're seeing, and this is even more evolving area in terms of how to respond. We're seeing them ask for police reports that weren't part of these are for U-Visa clients who also may have criminal issues in particular, whether they were juveniles at the time or they were adults, and often because they're a victim of crime, they got enveloped in the criminal system and ended up getting convicted of something. What we're seeing is Vermont asking for criminal records even when there wasn't a conviction for immigration purposes, and asking for documents that they wouldn't be allowed to ask for if they were in immigration proceedings, because the federal courts have found that many of these background documents, like police reports, are uncorroborated, which to them is hearsay, which means it's a serious due process issue if you rely on something that you can't challenge. So you have to think about, do I want to supply the unhelpful police report? And if so, then you're going to have to explain why it's unhelpful. We also have the legal arguments why asking for it violates due process, which is a constitutional issue. And again, this is going to be a case-by-case decision on whether you want to supply the things they're asking for that we don't think they have the right to ask for, even though they say it's to determine whether they're going to exercise discretion in favor of your client. To us, discretion doesn't mean they can violate basic principles of the Constitution. So nevertheless, it may be easier for you to just do it and get it approved, but we would ask that you still include these arguments that, yes, here it is, but we still think it's unlawful for you to ask for this because it violates due process, blah, blah, blah. And then it kind of gets into their brains that maybe they shouldn't be asking for this, and when they finally can take this to the Administrative Appeals Office as a legal issue, we'll hopefully have some traction with them. Okay. So I kind of discussed this. This case law says you really can't include police reports unless they're part of a record of conviction, which is this very weedy term of art in the criminal and immigration area. And, although they have discretion, it isn't unfettered discretion. They still have to follow basic principles of due process. Okay, the other area that we're seeing a lot of pushback is when you're asking for U visas under a category of crime where the crime that is listed on your certification isn't called that. So domestic violence hasn't been that much of a problem, but you could, because I think we trained them well on it, and they were used to this in the VAWA context. But as you know, there are many kinds of crimes that aren't called domestic violence, but they are domestic violence. So misdemeanor assault in your state is often going to be a domestic violence crime, but that's based on the facts of who the parties are involved. We're not seeing that so much of an issue, but I would, to be honest, would not be surprised if we start seeing it, because I don't think the adjudicators are understanding this category approach, which their own regulations say. Their own regulations say in the introduction to the U visa regulations, which I strongly encourage all you to read, a lot of really good stuff in there. They say, we're construing this list of crimes as a list of categories of crimes that Congress wanted to help survivors who are helpful to law enforcement. And we're considering them categories because we realize that across states, the same crime may be called different things. They didn't talk about domestic violence, but that's the most obvious category because in addition to misdemeanor assault, the things that I were talking about, like terroristic activity, could be domestic violence. Destruction of property could be domestic violence. It depends on the facts of the crime. The place where we're really having to duke it out with them, frankly, is in the felonious assault category. Early on, they agreed that robberies that contained the same elements of the crime as felonious assault fit in the category of felonious assault. That is pretty straightforward, and that comes from kind of a typical lawyer approach to statutes, which is you look at each part of a definition. Those are called the elements of the definition. And if the same elements are there for one thing, even if it's called something different, it still qualifies as the other thing. What we've been arguing is, as with domestic violence, even if you don't have all the same elements, if you have the facts that meet the elements of felonious assault, say a robbery plus in the description of the court documents, it says that the perpetrator used a weapon, that should qualify as felonious assault. So I won't go into this further. You can get back to me if you have cases like this. This could start happening in other categories as well. The one big practice pointer here is that framing these as similar, that extra category, really doesn't work because Congress did not intend the similar category to be this loophole that you could drive a truck through to get any other crime covered. They really wanted to cover these categories. If you have a question about whether a crime one of your survivors has encountered fits a category, again, contact us and we'll talk it through with you. Okay, I already went through all of this, I think. Extortion is the other area that we're seeing this in. What qualifies as extortion? Again, I think this has to do with just them being used to domestic violence and us having to educate them a little more on these other categories. So again, the elements, are the elements the same? Those are those pieces that define the category. If not, do the facts of the case supply a required element? And I think visuals really help. Lawyers tend to want to do a lot of briefing, but it's important to understand that most of the adjudicators at the Vermont Service Center and the Nebraska Service Center are not lawyers. The easiest way that you can show your argument, the better. I call it the normal person routine, right? So a chart where you show the elements and the facts on one side are the same as the elements of, say, felonious assault or another domestic violence statute. Okay, so if I know those of you who are doing U visas, I imagine a lot of your cases are just pending. Some of them may be on the wait list, and hopefully some of them have already been approved and waiting for adjustment. If you get an RFE for someone who was already put on the wait list, it may be because they've done another background check after they put your client on the wait list and they found more information that came to their attention. Or, frankly, it may be that they didn't do a very thorough job the first time before they put your client on the wait list. So you still need to reply to those RFEs unless you think they're wrong in what they're asking. They have agreed that they will not take away the work authorization, which is what that EAD is, Employment Authorization Document. You get those when your client is put on the wait list, and it used to be that when they issued an RFE, they'd also take away the work authorization, and they have now agreed that they won't take away the work authorization, but you really do need to reply timely, and it's obviously in you and your client's interest to resolve their concerns as quickly as possible. Because what it means is they're thinking of giving your client a U visa. If they're asking you an RFE after you've been put on the wait list, it means they're ready to give them a visa if they get what they need. Okay, so once you've had the U visa for 3 years, as you know, you can apply to adjust status. There have been far fewer problems so far in this area than with the U visas, but the one that we've seen coming up is them saying that your client hasn't proven ongoing cooperation with law enforcement and insisting on a new certification from law enforcement. That actually violates their own regulations. So if you have that problem, contact us right away and we will raise it with headquarters because that's clearly a training issue. The regulations themselves say that you don't need a new certification, and we suggest using the best evidence approach, which is show, that the case has been closed, or for some reason they decided not to prosecute it, or that even if it's ongoing, they haven't asked your client for any further information. I do think one good practice pointer that flows from this is in your own case file, is to have like a little flag for yourself that every 6 months you check in. If the case isn't closed, you check in on what's going on to say, hey, can we be more helpful? So that you can document that you at least tried, even if they didn't ask for any more help. One footnote on all this is that I think they're actually construing the statute backwards on this. The way I read the statute, the burden's on them to show that your client hasn't been cooperative. But frankly, we have so many other issues that we have to fix with them that this has never been one that we've really gone to the mat with them on. The reason the regulations have this caveat is because we did, in response to them, raise these issues. So they have backed off and acknowledged that you don't have to have a new certification. The other thing that's happening now is continuous presence, and this will happen because, especially now, when your clients are having to wait, 10 years before they can even get their U visa, and after that, they may have to extend their status because their derivatives didn't get it at the same time. And as you know, I hope, you do not want your principal U visas adjusting until all of the derivatives have gotten their U status. Because if a principal adjusts before a derivative has gotten status, either here in the United States or if they're abroad, processed in on a U visa, if she adjusts before then, their U visas are gone. And the only way that they can get status is through a 929 with the adjustment, and that's a lot harder. and the age-out provisions don't apply, which means if your client's abroad, if the derivatives have turned 21, they are out completely. So, given this long wait, it's not unlikely that your clients may leave the country. And of course, you can do all the warnings about travel and triggering new inadmissibility that will cause, but it doesn't mean they're not going to go back if they have to deal with a child who's in a bad situation, or, you know, the mom has died. And so they may have broken the continuous presence. And they may not be able to get back in without breaking the 3 years, the 180 days, 90 days required continuous presence. If they do break it, the good news is that although they haven't put it in writing, Citizenship and Immigration Services has agreed that you can reaccrue the presence. So once they come back in, as long as they stay in the United States long enough and can document it, they can regain their ability to adjust status. We have seen, in terms of showing the continuous presence in the United States, that they're getting more demanding in how often you have to show, like for the time frames, how short a time frame do you have to show that they've been here? Is it every month you have to show evidence they've been here, or is it every 6 months? Again, it seems to be that's an adjudicator-specific issue. So the practice may vary depending on what you can get, but the more evidence you can get for each month or each 3-month period, the better. Because then it's easy for them to see that your client hasn't left and come back in at all. Okay. And we talked about reaccruing continuous presence. Again, even though they haven't written it down, I have the brief that we helped some practitioners send to them, which then got an approval without actually acknowledging that's why they approved, after they had raised the problem of not having the continuous presence. Okay, so I'm going to do what are you seeing at the end. Sorry, I just need to get through this, and then we can come back to other issues that you're seeing, because we're almost done here. So for those of you who have heard us do webinars in years prior to this past year and a half, we have probably said that it was a good idea to do a motion to reopen or reconsider with Vermont rather than doing an appeal to the AAO. We've now basically reversed that position because we're not seeing Vermont fix anything, basically, unless it's, again, purely procedural mistake, and even then, sometimes not. And it's much better to take those questions directly to the Administrative Appeals Office in the form of a direct appeal than as a motion, because they could always deny the motion as untimely filed. You know, for purely procedural reasons, they could deny a motion to reopen to the AAO. So if you get to the point where you've gotten a denial and we don't think that Vermont's going to change their opinion on the denial, then we will work with you on going to the AAO, and we're trying to round up and do some amicus briefs for you on common issues that we want you to use when you go to the AAO, and also that we will file with the AAO. The Administrative Appeals Office is part of Citizenship and Immigration Services, so it's not an independent judicial review, which is another question we have been raising. In federal district court, we're starting to raise it because we think we need, in some cases, for instance, this good faith marriage, I have the feeling we're going to have to go to federal district court to get them to fix the problem. But it doesn't mean we have gotten some problems fixed with the AAO by going to the AAO, and it's worth doing, and they definitely pay attention to us when we file amicus briefs for you. So that's another piece. If you have law firms, big law firms that are interested in doing something helpful for immigrant survivors, we could really use some help from firms in putting together these amicus briefs that then we can all use. Okay, here are these.
Give me a second. Some people is having issues seeing the content of a slide.
What is, okay, we're at the end, so now we can do all the questions. I'll just leave up the resources here, and you can, let's go through the questions. So what do you mean the content of the slides? What do I need to explain?
So like white. So for those that couldn't be reading the slides, you can download the PowerPoint.
Oh, they couldn't even read them? I'm really sorry about that.
But I don't know why, because I can read that.
Yeah. I mean, the only good news I can tell you is that our slides are pretty minimalist. because we believe in using them as outlines. So I think we'll have a recording of this, and we can also send you the slides so you can listen to the recording again while going through the slides if you'd like. Okay,
Yes,
so Maria, what are the questions?
And we have a few questions from the first set of the VAWA request for further evidence. One is, what is the best way to get previously submitted evidence, like an I-130 or an I-751 package? Do you recommend filing a FOIA and wait to file the case?
Right. So this is Jessica Chico's question. This is actually, right. So this is a very good question because I did kind of assume it was obvious how you get these other applications. And Jessica's talking about, I think everyone can see this, right? So when she says FOIA, that stands for Freedom of Information Act, and that is important to do. I don't think you need to wait to get it to file an application. If you have done a FOIA and you haven't been able to get the I-130 and you want to file the I-360, I don't think you should wait. You need to talk to your client and find out if she has any idea what went on in that prior filing, but she probably doesn't, right? So the best you can do is be as clear as you can in your I-360 and just say, you know, we haven't been able to get the I-130. We have no idea what the abuser alleged in there. I mean, one way it can be useful, right, Jessica, is that he or she will have to have shown that he's a lawful permanent resident or U.S. citizen and hopefully the good faith marriage to your survivor. So, you know, you can't tell them to rely on that evidence, but hopefully there is some good evidence in there as well as some potential conflicts. It's always going to be a weighing pros and cons. I think with survivors, especially given the delays with U visas and that they're not even going to open the case for 2 years, it's better to err on the side of getting something filed and saying, look, we haven't been able to figure out what's in the other files you have. If you see any inconsistencies, please let us know right away so we can figure them out. Because that shows, you know, it shows that even if you can't immediately address any credibility issues, it shows that you are really entering this in good faith and that you want to explain everything to them and you're not trying to hide anything. And that's the way you want them to be thinking about you. Is you may not know everything, but you're not trying to hide anything. So should I just go? I can just go through these myself. Maria, what do you think? So Catherine would be next?
If you want to do Jessica, we finish with the VAWA questions. Then
okay, why don't we keep doing VAWA? Okay. So Jessica's next one is the basic question?
Yes.
Okay, so then Jessica asked, I don't think this is basic, Jessica, this is a good question. Do you recommend providing that amount of idiosyncratic detail for good faith marriage? Well, when there are children in the marriage, absolutely. I'll tell you, very early on, the first decade of VAWA, they said, you know, people keep thinking that because you have children with someone, it shows it's a good faith marriage. We don't believe that. So just so you know, that's where they're coming from. You know, obviously, it shows they at least had some sort of relationship for a very short period of time, if not a good faith marriage. But so do not assume that children by themselves indicate a good faith marriage. I think they're using this as a fraud check for VAWAs, the good faith marriage, because I think they're scrutinizing these much closer than they are regular family-based petitions. I think this is where it's worth putting the energy into a really detailed, factual, day-to-day discussion of the marriage so that it's clear that it's a real boring, typical marriage, you know? Okay. Oh, and Samantha, we're sorry. It looks like you had a problem with the slides.
Yes, Catherine has a question about I-918B.
Okay. So this would be Catherine's. Okay. So Catherine is asking, what about an original I-918B, which is the certification form, from police departments that are double-sided? Very good question. Yes, you should be able to do that. You might want to write in big red letters on the front page, see other side, you know, so that they know to look on the other side. Did you have any thoughts on that, Maria? Because I know you actually file these.
Well, I think you should photocopy the other side. Don't use double sides.
Oh, so don't use it. But the problem is it has to be an original, right? So they at least have to use the page that has the original signature on it,
Yeah,
right?
add the original, but put in between the other sides of the copies in photocopies.
Oh, good.
Yeah.
So include the double sides, but also include a copy of the second side so they don't miss it.
Yes. Because I think, if they photocopy or scan the case, they will not do the double side, and that's when you will be missing half of the information.
Okay, good. Well, so we only have one other question here. If people want to ask any kind of question, we've got plenty of time. I think Min Tam Lee had the other question, which said, responded to Vermont Service Center for a request for evidence and not heard from them at all. Emailed and got no response. It's been more than 6 months. Okay, that's way beyond their response time. So why don't you, this is so I can discuss a little bit how we help you with technical assistance. And everybody on this call, you get our help for free. So you see over here the questions at asistahelp.org. Send a question there, and what we'll want to see is what you sent to the hotline. And then what we can do is help you either reconfigure what you send it again, and then we can monitor why they didn't reply, and literally email the headquarters folks saying there's something wrong going with the hotline here. But we would need to see what you sent to see if maybe you didn't include the G28, or maybe you weren't listed on the G28 that was filed. That's the notice of appearance by the attorney. That's usually the reason they don't reply, but it also could be the wrong hotline address, who knows. So just send us a query about that, Min Tam Lee, and we will help you figure that out. Okay, so it looks like you did what you need. So forward to that questions what you sent them, and we'll get back to you, help you figure it out. Looks like some other folks are asking questions.
Typing questions.
Yep. Okay, so Jessica, when wishing to submit an amended I-751 based on battery extreme cruelty where a joint one was previously filed, and you have reason to believe it will soon be scheduled for an interview, do you recommend emailing VSC to ask them to hold the case and let them know an amendment supplement is coming? Is it the hotline email for 360s, or is there a 751 specific one? That's let me back up a second first and explain what you're talking about, Jessica, and then we'll talk about the strategy. So we didn't get into this, but the very first battery and extreme cruelty law that Congress created was a special waiver for conditional residents. Conditional residents are usually non-citizens who have married U.S. citizens and are able to apply for a green card within 2 years of marrying. It's if you're marrying a lawful permanent resident, you're not going to get your green card for most people in at least 5 years. So you wouldn't be considered a conditional resident. But if you get your green card within 2 years of marrying, you get what's called a conditional green card. The only condition is, however, that 2 years later, you have to jointly file this 751 form she's talking about, which is basically getting that condition removed. And it's essentially a fraud check, a marriage fraud check. The problem, obviously, is that it creates power and control, right? Because the abuser, has to sign off on that. So for those 2 years, you either stay in the marriage or you're going to lose your status and be deported. So in 1990, Congress created a waiver for that requirement that the sponsor, the abuser, sign that form. And that's what Jessica's talking about. That's where they created the formula for domestic violence that we use in immigration law, battery or extreme cruelty. So, Jessica, I'm just going to make some assumptions here that the 751 waiver was originally filed in Vermont, because Vermont still only has jurisdiction over 751s that are in their geographic area. The other service centers still have jurisdiction over their areas, which is a problem, I have to say. But let's assume it's in Vermont. Then in general, I would say absolutely, and this is a general suggestion, is that as soon as you encounter a survivor who has another kind of application pending, notify the part of the government, which is probably going to be some part of Citizenship and Immigration Services, that she is a domestic violence or sexual assault victim, and that 8 U.S.C. 1367, maybe you could type that in for me, Maria, applies. And Maria, maybe we could also send them that sample letter that we just used this morning in a technical assistance.
Okay.
Because there's a special law Congress created that says that as soon, or even if they suspect that a non-citizen is a victim of domestic violence, they can't take any information at all from someone who's an abuser. And what's the first thing that's going to happen when an abuser finds out that Jessica's client is trying to file her own waiver? He's going to call up the local immigration office or the office that has her file and said, she just made it all up to get immigration status. We literally had hundreds of stories of that happening, which is why Congress passed VAWA self-petitioning. So you do, as Jessica is saying, you do want to let, if Vermont is the place that got the 751 that had the abuser's signature on it, you immediately want to send a note to the email. I would do that, and also attach a declaration and the new waiver to that email and file it as quickly as possible with a cover letter that says, we want to let you know that the sponsor is an abuser and that 8 U.S.C. 1367 applies. So we hope that you haven't taken any information from the abuser, and please notice that there are significant sanctions if you do, and you use that information to make decisions on her case. Yeah, so you could do that. I think you, even if you want to have more time putting together an amendment or a supplement, Jessica, I would still notify them right away because you don't know what the abuser knows. And I do think we've seen cases, and I want to do a FOIA of the agency on how often they have gotten calls or emails or letters from abusers and what they've done with them. Because sometimes I think it looks like they're coming back with information to you that could only have come from an abuser. And we need to be using this law more than we have in the past. It's a really good protection that nobody else in the immigration system has, except for VAWAs and U visas and trafficking victims and these conditional residents who are victims of domestic violence. So hopefully I answered that for you, Jessica. But again, this is how we'll go through the actual facts with you probably if you contact us with technical assistance. So Suchi says, I filed a U visa in June for a client was an LPR, which is lawful permanent resident, but that person had been ordered removed and been removed. So I guess that means, Suchi, that they are no longer an LPR, right? They've actually been deported. Their LPR is gone. Yeah. So you filed a U visa for that person. Prior to her physical removal, you got an RFE on the criminal grounds of an inadmissibility. That's odd. Just a footnote is they've told us they can't give U visas to people who have LPR status, so I bet you anything they hadn't figured that out when they sent that RFE. Now that she's been removed and is no longer detained, I worry that CIS will bump her application back to the normal processing time and not issue a decision for many months. You know, it sounds like, as I said, it sounds like they weren't aware of the whole, they may not know about the removal and all of that, but I think, Suchi, this is a case where we really need to talk to you about what to do because she has probably now triggered some new inadmissibility grounds because she's been removed. And also she's going to have to process abroad, so you're going to have to do a change of address with CIS. And you should, this is an example of where I would do that heading them off at the pass because they're eventually going to notice that she had a green card at some point. So rather than waiting for them to notice this, say, look, she no longer has a green card in case you're concerned about that. She has this removal order, which may have caused these other problems, but here are the waivers that we're asking for these other problems. And by the way, she's now abroad. And so although I am, hopefully you are the safe address for her, Suchi, so you're getting any communications, she's going to have to process through the consulate to get back in with a U visa. So that's an important footnote. If any of you don't understand what I'm saying when I say safe address, there's a special rule in this system where you can use your address as the safe address for your clients. And this is really, really important if the abuser is still around. For like any of those cases where an abuser filed something before, that 751 we talked about, or a prior I-130 for a spouse, you need to use a safe address because we have seen, unfortunately, CIS inadvertently tell the abuser what's going on. in a client's case when you used by accident the address where she was still living with the abuser. Okay, I know I'm going off on tangents, but I keep thinking of things that would be good to mention. Okay, any other questions?
Yeah,
Got loads of time. Yep.
Oh, no, that was it. Yeah. Okay.
Okay, well, I don't see anyone typing. Oh, here we go. Jennifer asks, CIS is stating that the client abandoned the Form I-130 and denied the 480 file when she failed to show up for an interview a month ago. So you probably didn't know that that had been filed because your client is not the person who would have filed it. It's her sponsor, who is probably also the abuser, who filed it for her. And he has no interest in letting her know when her interview is. So this is an example of what we were talking about in the regular family-based context, is you do need to know the local office. Maria's going to send out the sample letter that you would actually use in exactly this kind of case, and you fill in the blanks for her. You need to immediately let that district office know that this is a self-petitioning case, and that if they should have known that he was an abuser, they have now violated 8 U.S.C. 1367. And or if they are now on notice that he's an abuser and they can't use any information from him in deciding her case. So contact us, Jennifer, because one thing we want to prevent is them actually issuing a notice to appear to put her into immigration proceedings. And the 8 U.S.C. 1367 argument will be very powerful for that. You don't need to reopen the I-130. That's closed. You're basically, what you want to do is you're replacing the I-130 with an I-360 for purposes of adjustment. So what we'd really like, if this were the perfect world where they hadn't already denied, what you would do is notify them and say, we want you to hold off on the interview, the adjustment interview, which is what the 485 is, until we get the 360 approved. And meanwhile, 8 U.S.C. 1367 applies, so you can no longer take any information from the abuser and you can't use anything he's told you in the past. And they're supposed to wait 30 days to see if you actually file the I-360. If you don't, then they can put her into proceedings. But if you do, they're supposed to hold off and reschedule an interview after the I-360 has been approved. But Jennifer, why don't you contact us and we can help you with the details of that. So now Jessica's asking, how many cases get RFE'd so that you can give clients an idea of what the chances are of this happening with a complete application? Well, Maria, I do TA, so all I see are the cases that get RFEs. I don't see the ones that don't get RFEs. In your experience, Maria, what percentage would you say get RFEs?
I don't know percentage, but if client has criminal history, 90% you will get an RFE.
Yeah.
Yeah, that for sure. Or double arrest, they will get an RFE, and you may need to supply a declaration explaining why the double arrest. And also, if it's a straight VAWA case, easy evidence, those cases are approved in 6 months or 4 months.
Okay.
But when you have criminal convictions, entries and exits, that's when you get an RFE.
Yep. Okay, so that's helpful, and it's also an important reminder that given how long it's taking for U visas to even get their case open, it might be worth going through your case files and targeting, pulling out the cases where someone might qualify for a VAWA self-petitioning or a trafficking visa, because those are much faster. It does mean, because they're faster, you probably need to put more effort into ensuring you're at finding all of the problems up front and addressing them. But again, we can help you with that. Okay, so now Catherine says, our office has several cases where the applicant was granted U status months ago, but the work authorization documents have not arrived yet. That is strange.
Yeah.
She says, I've heard something about getting an InfoPass meeting at a local CI office, and they may, no, you don't want to be getting your work authorization from the local CIS office. No, that's going to really mess everything up, because the only office that has jurisdiction, has the authority to issue the work authorization for U visas is the Vermont Service Center. And we do see other parts of the government trying to be helpful and do things that they think are being helpful, and it ends up completely screwing up the case. It's all procedural, again, is the problem. So you should not be waiting that long to get your work authorization documents. Again, that's where you send us the information. I'll send you a format that we want you to use for communicating with CIS that makes it really easy for them to see what the problem is. And then I'll send this to the heads of the unit, because this is the kind of thing that they will address. This kind of purely, think the process isn't working right, as opposed to, you're wrong on the law. Several clients have been waiting since May. Okay, so this sounds like it might be a systemic problem. So let's get a list of all, and any of the rest of you have been waiting a long time to get work authorization after you has been granted, send those to us, because we will both intervene with headquarters, and we may want to talk about other ways to make them get off their butts and issue it. Like we've got this whole project on mandamus in federal district court to get them to issue work authorizations, which is a whole other thing. But if you're interested in that, let me know. We have a working group on that. I'm just waiting. There are people typing, as hopefully you can see. Okay. All right, so Catherine says she also has a principal U with 4 derivatives. The principal and 3 derivatives were approved. Only one of those has received the work authorization. The youngest son, 14 years, has not been issued an approval. That's very bizarre. The hotline has said the case is under review. So, Catherine, it seems very weird that a 14-year-old would be the one that has problems. Why don't you contact us to figure out why they could possibly be flagging the 14-year-old? Oh, the principal has not. I don't know what that means, approved in May. Okay. All right, Jessica has, we've seen work authorizations changed from A19 or 20 to C14 once they got on the wait list. Okay, well, they're not actually changing it. What they're doing is what they can do, is that for the wait list, the only kind of work authorization they can issue is C14, because the A19 and A20 work authorization categories are only for people who have approved U visas. So the only way that people are getting on the wait list is they're getting deferred action, and C14 is the basis for that. If you've done VAWAs in the past, you're probably familiar with that similar kind of thing, is that while they were waiting to be able to apply for a green card, the only way they could get work authorization is based on deferred action, which is C14. Now, since now Congress has made it what we call attendant to approval, so as soon as they approve, they can get a different category. So what's going to happen, Jessica, is once they actually get approved, they'll switch from C14 to A19 or 20.
But
yeah. You want to address the having to submit a new 765?
Yes. When
so,
you file your,
Maria, what do you think the best practice is for work authorizations given the wait list and the long delays in getting A19 or 20?
Okay. For U visa cases, when you file your U application, you will send EADs under A20 for derivatives and EADs under 12C14 for everyone. So you will have 2 sets of derivatives for every person. Once the case is put in waiting list, the derivatives under 12C14 will be approved. And when the U visa is approved, you will get the long EAD that is valid for 4 years under the code 19 or 20 that are for the U visa.
So you're doing it. You're literally doing a 7. Like, say you had 4 derivatives and 1 principal. You do 9 765s or 8 765s.
Correct.
Yeah.
And
okay.
And
you can do fee waivers, I assume, right?
Yes. Yes.
Okay.
You can do 1 fee waiver and photocopy, just as the client to sign original photocopies.
Right.
But you don't need to complete the form over. But be careful about submitting 2 sets of pictures per I-765, and because the EID is done by an outside agency, always to make it easier for them, attach a birth certificate and the translation along with the I-765. So do like 1 package for each set of derivatives.
So what's the birth certificate for, to show identity?
Yes.
Okay, and you don't want to attach original birth certificates probably, right?
No, that's the problem. What they do is they will take the 765 package, you know, and put it apart. So if you are missing the birth certificate, then they need to go back to the case, photocopy the case, and that will delay the case. So do an extra set of birth certificate and translation, I-765, fee waiver request, and the pictures.
And for principals, theoretically, because they get work authorization when the U is approved, you only need the 765 for deferred action while they're on the wait list, right?
Yes.
Okay. So I know this is really complicated, and again, it seems like it's putting form over substance, but this is just what we've learned. They're very procedure-oriented. And as she said, it's actually a different part of the agency that does the work authorization documents, which I imagine is where the breakdown in communication is happening in what you were talking about. I think it was Catherine. Yeah. Any other questions? We're happy to talk about anything. Okay, well, we've ended very early, but we're very glad that all of you were able to join the call. If some of you may be new to this area, and I imagine this was completely mysterious to you, if that's true, but you should, if you can see our website over here, and we tape all of our recordings, and they're all available for free. So, and there's a whole lot of other information on our website that's for free. So if you need more background information, please go there. And we are here to help you with any kind of question. Contact me directly, Gail, or you can send it to questions, and that Maria will help. Maria, I always, as you can tell, I turn to for all the basic, like how do you file this and when do you file that kind of thing. I'm more the policy theory, moving the law kind of person, and I do the communicating with the government. So, thank you all very much, and thank you, gals at the, oops, Claudia's typing something.
And one more thing, we welcome all suggestions for webinar topics. If you have some ideas about any topics that you want to cover, send us an email.
Very good point, yes, because we will be doing this for the next 2 years. We have been approved to continue doing this for you. So do send us, we're at the point, actually, we're going to be meeting with our program manager in the next couple of weeks to plan our webinars. So let us know what you want us to do, and we will do it for the next few years. Thank you all. Thank you, NCJ, FCJ gals, for helping us out. And we will get back to you with any materials we discussed here that weren't already attached.
Great. Thank you.
Bye.
Bye.